So imagine this. You've got a simple plumbing problem in your home. No big deal, right? Well, now imagine it drags on for months and months, making your property completely unlivable, and then you find yourself in a full-blown legal battle with your homeowners association. This isn't just a story about a leaky pipe. It's a really fascinating look into responsibility, rules, and the challenges of living in a community run by volunteers.
We're going to dive into the case of Nicholas Thomas versus the Tanglewood Association. Yeah, it all started with a flooded kitchen sink, but it ended up in front of an administrative law judge, and it really pulls back the curtain on the struggles of managing a shared property.
So, how did a simple plumbing issue get so out of hand? Let's walk through the timeline of events that turned what should have been a maintenance call into a formal day in court. What's wild here is just how fast this all went downhill. We're talking about just 4 months between reporting the issue and the tenant having to move out and a legal petition being filed. That tells you there was a serious breakdown somewhere, whether in communication, action, or, maybe both. And when the owner, Nicholas Thomas, finally got to speak at the hearing, he painted a pretty grim picture. This quote really gets to the heart of his frustration, and it's the whole basis for his first complaint against the Tanglewood Association, that they just failed to fix a fundamental problem.
All right, so the first official complaint was, on the surface, pretty straightforward. Mr. Thomas basically said, look, the HOA is responsible for the common plumbing lines, it's been 7 months, and my property is still unlivable. Simple as that.
And this slide, this is where you can see the two sides were just on completely different planets. For the owner, it was a clear failure of duty. But for the HOA, it was this tangled mess of procedures, red tape, and of course, a huge price tag. Now, the HOA knew a fix like this wouldn't be cheap. They'd been down this road before. Just a few years earlier, they had to shell out $15,000 for a similar issue in another building. So they had a precedent. But this problem? This was a whole different beast. After getting quotes, the board realized the work was way more extensive. The cost had ballooned to an estimated $70,000. I mean, that is the nightmare scenario for a small, self-managed HOA. It's a massive, unexpected bill that just dwarfs your budget.
And here is the real kicker. According to their own rules, their own governing documents, the HOA couldn't just go out and spend that 70 grand. They had to issue what's called a special assessment. And to do that, they needed to get more than half of all the homeowners to vote yes.
And this is where the HOA's co-president, Hector Saavedra, pointed out a huge problem. He explained that just getting owners to show up and vote was a constant, exhausting battle. And then he drops this bomb. He points out that Mr. Thomas, the very guy filing the complaint, hadn't even voted himself in years. It just perfectly illustrates the challenge of community inaction. Okay, let's switch gears to this second complaint, because this is where things get even more interesting. For Mr. Thomas, this wasn't just about a broken pipe anymore. It was about who was supposed to be in charge of fixing it. He basically argued that a volunteer board, made up of his neighbors who all have their own jobs and lives, was just not equipped to handle big money decisions and complex repairs. His solution? Force the HOA to hire a professional management company. And honestly, Mr. Saavedra didn't really argue the point. His testimony gives you this powerful glimpse into the reality of being a volunteer. He's a full-time architect, but he's getting more calls about HOA stuff than from his own clients. You can just feel the stress and the personal pressure on these unpaid board members. So, the arguments are in, the frustrations have been aired. Now, after hearing from both the frustrated owner and the struggling board, the administrative law judge had to make a call, based purely on the community's own rules and the law. So the central question for the judge wasn't really about what seemed fair or who was having a worse time. It was way more specific. Did the Tanglewood Association legally violate its duties according to its own rulebook? In a case like this, everything comes down to a really important legal idea, the burden of proof. It sounds complicated, but it just means that for Mr. Thomas to win, he had to be the one to prove that the HOA had, more likely than not, actually broken its own rules. So the judge broke it all down, piece by piece. First, she looked at the HOA's own documents, and yup, they said the board couldn't spend more than $5 grand without approval. The repairs were estimated at $70,000, so the board's hands were legally tied until they could get that community vote.
And this is crucial. The judge found that the board did take action. They got quotes, they tried to hold a vote. She concluded that the delays were caused by the voting process itself, not because the board was just sitting on its hands and ignoring its duty.
And so, at the end of the day, the judge concluded that Mr. Thomas just hadn't met that burden of proof. The verdict came in, petition denied. The HOA was legally the prevailing party in the case.
Okay, so the case is over. But what can we all take away from this? Because this story offers some really, really important lessons for anyone who owns a home or lives in a community with an HOA. The lessons here are crystal clear. First, you have to know the rules of your own community. I mean, the outcome of this entire case hinged on a spending limit written in a document. Second, you have to participate. This whole crisis dragged on because the board couldn't get enough people to vote. And finally, document everything. Clear communication records are your best friend if a dispute ever pops up. And all of this leaves us with one final big question. This case was never really just about one backed-up sink. It's about a much larger issue that thousands of small, self-managed communities are facing everywhere. When things go wrong, does the responsibility fall on the overworked volunteers to magically find a solution? Or does it fall on the community members themselves to actually show up, vote, and provide the funds to get things done? It's a tough question, and there's definitely no easy answer.